Hello, my name is Gerardo Ramirez in the Federal Program Compliance Division of the Texas Education Agency. This presentation will provide a basic overview of the Title I Part D program. This presentation provides general program information and should not be used as an all-inclusive overview of all Title I Part D statutory requirements in the Every Student Succeeds Act, referred to as ESSA in the presentation. The Title I Part D is composed of three subparts. Subparts 1 and 2 establish the prevention and intervention programs for children and youth who are neglected, delinquent, or at risk. This law provides supplemental funding to state and local education agencies as part of the Elementary and Secondary Education Act, as amended by the Every Student Succeeds Act. Subpart 3 establishes program evaluations that must be conducted for any programs under Subpart 1 and 2. These funds are dedicated to improving educational services to children in facilities for the neglected or delinquent. The goal is to enable program recipients to meet the same student performance standards that all children in the state are expected to meet. Improved academic performance will facilitate the transition of students from correctional programs to further education or employment. The Department of Grant Compliance and Administration at the Texas Education Agency administers two formula grants under this law. Title I, Part D, Subpart 1 covers state agencies, Wingham School District, and Texas Juvenile Justice Department. And Title I, Part D, Subpart 2 covers the local education agencies. Always remember that Subpart 1 funds are meant for state agency programs, while Subpart 2 funds are meant for local education agencies. There are three purposes of the Title I, Part D, Subpart 2 program. The funds must be used to carry out high-quality education programs to prepare children and youth for secondary school completion, training, employment, or further education. To provide activities to facilitate the transition of such children and youth from the correctional program to further education or employment, and to operate programs in local schools, including schools operated or funded by the Bureau of Indian Education for children and youth returning from correctional facilities, and programs which may serve at-risk children and youth. There are 13 requirements for the Title I Part D Subpart 2 subgrantees. These requirements are listed in the Title I Part D Program Guide and the ESSA Consolidated Program Application Handbook. These are: provide a description of the program, provide a description of formal agreements between the LEA and correctional facilities and alternative school programs, including Secretary of the Interior and Indian tribes, provide a description of coordination with facilities working with delinquent children and youth, ensuring their participation in comparable local school education programs, provide a description of programs to facilitate successful transition of children and youth returning from correctional facilities and types of services offered, provide a description of characteristics, including learning difficulties, substance abuse problems, and other special needs of the children and youth returning from correctional facilities. Describe how the LEA will coordinate existing educational programs to meet the unique educational needs of children and youth. Provide a description of how the LEA will coordinate with existing social, health, and other services to meet the needs of students returning from correctional facilities, including prenatal health care and nutrition services, parenting and child development classes, childcare, target reentry and outreach program, referrals to community resources, and other flexibility. Provide a description of partnerships with institutions of higher education or local businesses to facilitate post-secondary and workforce success for children and youth returning from correctional facilities, such as career-bearing coursework, enrollment in post-secondary education, participation in career, technical education programming, and mentoring services. Provide a description of how the program will involve parents and family members to improve the education and achievement of the children, assist in dropout prevention activities, and prevent involvement in delinquent activities. Provide a description of coordination with other federal, state, and local programs, such as Title I of the Workforce Innovation and Opportunity Act and career and technical education programs. Provide a description or coordination with Juvenile Justice and Delinquency Prevention Act of 1974, if applicable. Provide a description of coordination and collaboration with probation officers to assist children and youth. Provide a description of efforts to ensure correctional facilities are aware of the child's existing individualized education program, and provide a description of steps the LEA will take to find alternative replacements for children and youth interested in continuing their education but unable to participate in a traditional public school program. In order for a facility to be considered under this program, it must meet one of these definitions. An adult correctional institution is a facility in which persons under the age of 21 are confined as a result of a criminal offense conviction. A neglected institution is a facility, either public or private, other than a foster home, that is operated for the care of children who have been committed or placed by the state law due to abandonment, neglect, or death of parents, guardians. A delinquent institution is a facility, either public or private, other than a foster home, that is for the care of children who have been adjudicated to be delinquent or in need of supervision. At any point, the LEA may submit documentation for either of these facilities. Now that we talked about delinquent youth and that they need to be adjudicated, let's chat about what does adjudicated means. A simple search engine search will tell you that adjudicated simply refers to the formal legal process by which a judge or arbiter reviews evidence, including legal reasoning offered by litigants or opposing parties, to come to a decision on legal matter. Remember that the youth need to be adjudicated to be delinquent or in need of supervision in order to meet the eligibility criteria for the program. Now we will cover eligibility for Title I Part D Subpart 2. In order to apply for Title I Part D Subpart 2 funds, the LEA must meet at least one of the following criteria. They must serve a student who live in a residential facility for neglected or delinquent. They must have a residential facility for the neglected or delinquent located within its boundaries. Or they must be in an open enrollment charter school that either operates a residential facility for the neglected or delinquent or provides educational services to students who live in such facility. By now, you have heard mentioning of neglected and delinquent multiple times. Before we go any further, let's take a look at the definition of each term. The official definition of neglected student is a child, youth, or student who has been committed to an institution other than a foster home or voluntarily placed under applicable state law due to abandonment, neglect, or death of his or her parents or guardians. The official definition of delinquent is a child, youth, or student who resides in a public or private residential facility other than a foster home that is operated for the care of children and youth who have been adjudicated delinquent or in need of supervision. The LEA will make the decision of what youth is being serviced and what is being documented. Now that we have established the definitions of neglected and delinquent, we also have to keep in mind other student eligibility criteria. The students must meet the following: have resided in a facility at least one day in October, be between ages 5 to 17, exclude children under conservatorship of the Texas Department of Family and Protective Services, and exclude foster care children. The at-risk definition found under Title I Part D statute is different than the one found, for example, in Camp Ed. As you can see on this slide, the definition of at-risk for the Title I Part D program is much broad and is intended that way in order to allow flexibility for LEAs to implement the program. Please refer to the program guide for more information. The Title I, Part D, Subpart 2 requires the LEA to describe how they will involve parents and family members of the children's service in order to improve their educational achievement, help in dropout prevention, as well as help preventing involvement of their children in delinquent activities. We will now cover some use of funds. When determining allowable use of funds, the LEA is responsible to make sure that it's reasonable and necessary, reviews the comprehensive needs assessment, looks at the evaluation of student achievement. Furthermore, when determining allowable use of funds, always keep in mind EDGAR requirements as well as district policies and procedures. Here are some of the recommended uses of funds. Under Title I, Part D, Subpart 2, S. Statute 1424, LEAs may use funds for programs that serve children and youth returning to local schools from correctional facilities and assist in the transition. Dropout prevention programs serving at-risk children and youth. Coordination of health and social services for youth to improve likelihood of youth completing education. Special programs to meet unique academic needs, including career and technical education, special education, career counseling, curriculum-based youth entrepreneurship education, and financial aid assistance for post-secondary education, as well as mentoring and peer mediation programs. As previously mentioned, transition services are one of the recommended uses of funds. I would like to take a moment to highlight the importance of transition services. These services focus on helping children who are neglected or delinquent re-enter school successfully or to find employment after they leave the institution and return to the local community. It is important that the LEA has a transition plan in place in order to help youth with reentry. Some of the allowable activities include but are not limited to pupil services, including counseling, psychological, and social work services designated to meet the needs of children and youth who are neglected or delinquent, tutoring and mentoring, as well as reentry orientation programs, including transition centers and reentry centers in high schools. Another of the allowable use of funds is to use funds for Pay for Success initiative. The question that we get often is, what is Pay for Success initiative? This initiative is a performance-based grant, contract, or cooperative agreement awarded by a public entity in which a commitment is made to pay for improved outcomes that result in social benefit and direct cost savings or cost avoidance to the public sector. Now we will go over program evaluation. As mentioned previously, Subpart 3 establishes the program evaluation for Subpart 1 and Subpart 2. In conducting each evaluation under Section 1431, an LEA shall use multiple and appropriate measures of student progress. Each LEA will submit evaluation results to TEA and use the results of evaluations to plan and improve subsequent programs for participating children and youth. More information regarding Title I Part D program evaluations may be found in the program guide. The Texas Education Agency is in charge of conducting compliance and monitoring every year. We will now take a look at this process. Compliance monitoring occurs in a three-step process. USDE monitors the state, TEA will monitor the LEA, and the LEA monitors the facility. Keep in mind that since the LEA is the one receiving the funding, they are the ones responsible for the appropriate implementation of the program. Upon certification and submission of the ESSA Consolidated Federal Grant application, LEAs certify that they will comply with all requirements noted in statute. All requirements can be found in the program-specific provisions and assurances posted on the TEA Grant Opportunities page. For a link to the program-specific provisions and assurances, search by the grant application name and review the information located in the Application and Support Information section. To monitor the compliance of each eligible entity receiving ESSA funds, the state conducts an annual validation process for LEAs. The annual validation process for LEAs addresses the statutory requirements based on program implementation and effectiveness for the current grant year. During the annual validation process, the state randomly selects LEAs to submit documentation for the program compliance requirements. TEA reviews the documentation to determine if the subgrantee met the statutory requirements as noted in the validation guidance documents. The Federal Fiscal Monitoring Division is responsible for monitoring the expenditures of federal grant subrecipients to ensure federal funds are used for authorized purposes in compliance with federal statutes, regulations, and the terms and conditions of federal awards. The ESSA Consolidated Compliance Report is completed by LEAs annually to document that LEAs have complied with the program-specific provisions and assurances in the preceding application year. LEAs are responsible for indicating the sources of documentation used to establish compliance. The documentation is to remain on file at the LEA level. However, It must be readily available upon request from the Texas Education Agency for audit and/or validation monitoring purposes. The ESSA Consolidated Compliance Report will assess specific statutory requirements. Now, let's talk about the new facility programs as released by the Department of Education. The U.S. Department of Education, alongside the Office of Management and Budget, have worked on a packet for data collection covering years 22-23, 23-24, and 24-25. In this packet, we see the inclusion of different facility types, such as the ones listed on the slide. Breaking it down, we have the law, ESSA, that provides guidance between neglected, delinquent, and at risk. Now, thanks to the new definitions, we see that under neglected, we have new facility types, such as group homes, shelters, community day programs, residential treatment centers, and other. On the delinquent side, we have new facility types such as adult corrections, community day programs, juvenile detention centers, shelters, group homes, ranch wilderness camps, residential treatment centers, long-term secure juvenile facilities, and other. Please note that these changes are on the way we report data, not on the program requirements. For more information, please check out the compliance report instructions. TEA has produced some resources available to everyone. Up next, we will cover some of these resources. A major resource is the Title I Part D Subpart 2 Program Guide. This program guide covers the requirements for the Title I Part D Subpart 2. It is available on the TEA page of the Title I Part D. Another major resource is the Frequently Asked Questions document. This document covers frequently asked questions that have been submitted to TEA for clarification. Thank you so much for your time and attention. If you have any questions, please reach out to the contact information posted.